We have all heard the term company, but what exactly is company? Company is a separate legal entity. The capital is given by shareholders and management is vested with the board of directors. So the big question is, who is more powerful, the board of directors or the shareholders? The Companies Act 2013 gives us the answer in section 179. In layman's terms it says if the company had brains of its own, whatever the company could have done, the board of directors shall be entitled to do the same, so it appears that the board is more powerful. On the other hand, the second proviso of the same section says that the board shall not do those things which the shareholders can do. And what can the shareholders do? The powers of shareholders are vested in the Companies Act, the Memorandum of Association, or the Articles of Association. MoA is the external charter of the constitution of the company, whereas AoA are the internal regulations of the company. For instance, if I see section 179 subsection 3, it says powers like borrowing money, investing funds, granting loans are all vested only with the board of directors, which they have to do only through a board meeting resolution. Can the shareholders interfere? No. On the other hand, if the shareholders want to remove a director, they may do so in a general meeting as per section 169. Can the directors interfere? No. So it appears that the Companies Act has given a clear two-tier mechanism where some powers are given to the board of directors and some powers are given to the shareholders. Surprisingly, in some cases both the board and the shareholders should come together to pass a resolution. For instance, if the company wants to sell an undertaking that is maybe a small branch, then it needs the approval of both the board and shareholders. This is given in section 180. But what if the act is silent? For instance, in section 101, with respect to notice of a meeting, where shareholders should be called for a meeting, the act is silent as to who will give notice. Generally the board calls the meeting, but in some cases the shareholders also can call for a meeting. So should the person calling a meeting give the notice is the question? Section 101 is silent on this issue. We take recourse to section 179, which says if the company had brains of its own, whatever the company could have done the board can do. Hence, it is the board who should give notice. This was upheld in LIC vs. S Courts Limited case as well. So it is suffice to say that board of directors are the brains of the company. Next question plaguing us is, can the AoA or the MoA override the act, or is it the other way around? Section 6 gives us the answer. The act is always supreme. The act overrides AoA and MoA. Let us assume you are a shareholder of the company. You walk into the company and ask the company secretary to show the accounts of the company. Are you as a shareholder entitled to access the accounts of the company? The answer is a resounding no. Section 128(3) gives the power only to the directors. So the shareholder has no control over the company? Can he interfere with the board's powers? The Act beautifully illustrates this point. Section 152(2) and 160 give the power to only the shareholders to appoint directors. If the shareholders don't like the director, they can remove the director under section 169. Since the shareholders don't have the power to inspect the books of accounts as already discussed, they can appoint qualified chartered accountants of high caliber as auditors to check the work of the directors. They can also remove the auditor if they so choose. These are called the 4 pillars of corporate democracy. So coming to the question, who is more powerful, board or shareholders? We can conclude by saying that for day-to-day operations, board of directors are more powerful. And for important areas like appointment of board and auditors and other things, it's the shareholders. 179 is rightfully called the mother section of Companies Act. For more videos, subscribe to this faculty's YouTube channel.